Hello, Hidden Gems. Twice in one day, I know. Well, Lori's back at it. Her legal filings have been flooding the court docket in the past 24 hours, and I am here to break it all down twice in one day. Someone hand Lori a legal pad and a decaf, or maybe hand her one of her famous protein shakes. If you know, you know. And if you missed this morning's video, I'll drop the link in the pinned comments and description of this episode because, wow, my earlier video today covered Lori's fiery reply to the state's response to her motion for a mistrial, and she was mad. But wait, there's more. Hidden True Crime has just obtained a fresh stack of court filings. 3 big motions from Lori, plus the state's equally hefty responses to each. They are all in relation to Lori's upcoming trial next month, her third trial, where she faces charges of conspiracy to commit murder again, but this time the victim, luckily, survived. Her ex-nephew-in-law, Brandon Boudreaux, will be testifying about the bullet that shattered his Tesla window, missing him by inches as he pulled into his own driveway. He will be one of the state's main witnesses, and Lori wants to suppress evidence before heading to court to represent herself once again. And leading the legal parade is Lori's motion to dismiss some very crucial evidence. In this first handwritten motion we're about to discuss, Lori writes, quote, Lauren Daybell requests this court to dismiss the charges. Yes, pause. She is requesting the court dismiss all of the charges, the upcoming charges, the entire charge. And we'll go back to what Lori is writing. This is a handwritten motion again. She says, since the state of Arizona did not preserve the crucial evidence of the car door or the car window of the alleged window, she calls it the alleged window, it is a violation of the 6th and 14th Amendment of the United States Constitution and the defendant's right to due process and the right to a fair trial. The lack of preservation of this crucial evidence is prejudicial to this defendant and to her defense team. The defense has requested of the state the actual door of the car that was allegedly shot and the window of the car door that shattered as a result of the alleged gunshot. The defense was informed by the state that they do not have and did not preserve the car door or the window of the car door. Therefore, they are not available to the defense to do their own independent investigation of these 2 crucial pieces of evidence in the case. Pause really quickly, Lauren, now, in other words, she is saying that she wants to be able to take this evidence, do her own investigation of this evidence, the car door and the car window, and she can't. Thus, we need to these 2 crucial pieces of evidence in this case, the defense cannot do their own investigation. Lori continues, quote, there are nothing but pictures of the car door and the car window. Therefore, the defense and its experts cannot measure or test anything about this alleged shooting. This is a violation of the state, precluding the defense from doing an independent investigation of this case. This is a violation of the defendant's 6th and 14th constitutional rights and calls for dismissal of this case, end quote. So now the state, they are not having any of this. In their response, they claim that the Gilbert police did not act in bad faith when they did not impound the Tesla. More specifically, but this is how the state responds to Lori's motion. They reply, quote, on October 2nd, 2019, Brandon Boudreaux was residing at 3875 E. Phelps Street in Gilbert, Arizona. And that morning, he left his residence at approximately 7:25 a.m., took his children to school, dropped off his youngest with his soon-to-be ex-wife, and went to the gym. Around 8:40 a.m., a neighbor was backing out of his driveway and observed a Jeep parked next to Boudreaux's driveway. The Jeep was parked so the front of the Jeep was facing the front of the white SUV. The neighbor noted that the Jeep was running, had tinted windows and a Texas license plate. The neighbor had never seen the Jeep before. And then at approximately 8:48 a.m., another neighbor was walking his dogs when he saw a Jeep parked with the front of the Jeep facing the front of a white van in front of Boudreaux's residence. The neighbor noticed the Jeep. One second, everyone. Forgive me, I have a bit of a cough. Let's get back to it. Thanks, guys. The neighbor noticed the Jeep was running and that the driver's seat was pushed all the way forward to the steering wheel and that he could not see the back of the Jeep due to the tinted windows. Boudreaux returned home at approximately 9:13 a.m. and as he approached his driveway, he slowed as his Tesla began opening the garage door. As Boudreaux slowed, he noticed a Jeep parked next to his driveway. Boudreaux watched as the rear window of the Jeep lifted up and a rifle barrel pointed out of the rear window. Boudreaux heard a loud bang and his driver's side window shattered. Boudreaux hit his gas and drove away from his house. Boudreaux called 911 and returned to his house. And when Boudreaux put his Tesla in park, the driver's door automatically opened and the driver's side glass window fell out of the frame and onto the driveway. When police arrived, they noticed the hole in the driver's door frame and the driver's side glass laying on the driveway. Police recognized the hole as being made by a bullet. Gilbert police detectives went to the scene, took photographs of the street where the shooting occurred, the glass in the street, the white van and area around the white van that was mentioned by neighbors, the Tesla in the driveway of 3875 East Phelps Street, the gunshot hole in the door frame of the Tesla and the driver's side window that was laying in the driveway. The police also took photos of the Tesla with a trajectory rod in the bullet hole and the bullet fragments that they collected from the door frame. The Gilbert police report and impound sheets showing that the Tesla and driver's side window were not impounded was disclosed to the defendant on December 12, 2023. And on October 2nd, 2019, Lori Vallow and her co-conspirator, her brother, Alex Cox, were living in Rexburg, Idaho. In the days leading up to October 2nd, 2019, Lori Vallow provided her deceased husband's 2018 Jeep Wrangler to her co-conspirator, Alex Cox, to Arizona to shoot Brandon Boudreaux. Before Alex Cox drove to Gilbert, Arizona, he took the 2018 Jeep Wrangler to a tint shop in Rexburg, Idaho, to tint the windows so that no one would see him in the rear of the Jeep as he lay in wait for Brandon Boudreaux to return home. And on October 1st, 2019, Lori Vallow, the defendant, rented a storage unit in Rexburg, Idaho. And while Alex Cox was driving the Jeep to Arizona to shoot Boudreaux, Lori Vallow stored the Jeep's spare tire and rear bench seat in her storage unit. While Alex Cox was committing this shooting in Gilbert, Arizona, Lori Vallow Daybell was in possession of her co-conspirator's cell phone in Rexburg, Idaho. And on October 2nd, 2019, at 8:02 a.m., the defendant used the co-conspirator's cell phone to call her cell phone to make it appear that her co-conspirator was still in Rexburg, Idaho at the time of the shooting. End quote. Wow. The state then cited case law before ending by saying, quote, the defendant can argue that the police were negligent in not impounding the Tesla and or glass, but there is no bad faith in their decision not to impound the vehicle. No amount of testing of the Tesla by an expert would provide evidence that would exonerate the defendant from the actions she was taking to aid her co-conspirator from Rexburg, Idaho. The defendant has had the police reports that show the Gilbert police did not impound the Tesla since December 12, 2023. The defendant has failed to show any bad faith on the part of the Gilbert police in their decision not to impound the Tesla or the glass window. The United States Supreme Court has held that, quote, failure to preserve useful evidence, end quote, does not violate the defendant's due process rights. And here, the Gilbert police failed to preserve evidence that has extremely limited evidentiary value and no value to exonerate the defendant's actions that were occurring in another state. And therefore, the state requests this court deny the defendant's motion to dismiss. End quote. What a motion by defendant Lori Vallow, and what a response by the state. But that is not all. Up next, hit the docket today as well, Lori's motion to preclude all evidence of phone data and text messages relating to Alex Cox. So first she tried to just dismiss the charges, but somehow I guess she's also saying, and if we're not going to do that, we need to preclude all evidence of phone data and text messages relating to Alex Cox. She wants to silence her brother and co-conspirator Alex Cox from beyond the grave. It's handwritten, this motion, and let's unpack it now. Lori writes, quote, pursuant to the Rule 801C hearsay, Rule 801D, procedural rule or context statute hearsay is inadmissible unless it is defined by non-hearsay under Rules of Evidence Rule 803. In order for text messages to be relevant, it must establish the defendant's intent, knowledge, and absence of mistakes. So I guess text typos. The alleged co-conspirator is deceased. Therefore, the state cannot establish Alex Cox's intent, knowledge, or absence of mistakes, end quote. Now, honestly, when I read this, I wonder if she has a point. I'm not an attorney. Alex Cox is not here to establish intent, correct, or correct the absence of his mistakes in his text. Then Lori jumps to some legal jargon in this handwritten motion, or should I say Laura-Lee's. So under the section she has labeled as facts, it reads, quote, and I'm just going to read them all. A, in Olmstead, telephone messages are inadmissible. B, Federal Wiretap Act, SCAECPA, USCA Constitution, Article 3, State Invasion Privacy Act prohibit unlawful access to stored electronic oral communications, re Facebook. C, torts, IPA bars, reading or attempt reading of any message, 18 USCA 2512A. The data contained is unreasonable. Servers, web hosts are overseen breaching foreign treaties. And in response to metapixels or pixels that track IP addresses and devices, they violate USCA Constitution Article 3. Search warrant, E, search warrant application for location information violates pen register and tap and trace, cell site location info. Stored Communication Act, SCA does not permit government to obtain requested ping warrant, end quote. So after she writes all of that out, Lori goes on to write, quote, in Homestead proves under Wiretap Act, the telephone messages cannot be intercepted. A warrant cannot be provided. In Riley, data goes to cloud computing and server connects to web host, which most are foreign entities. Web host opens to Pixel. Pixel tracks the device. Servers, web host, pixels, data, and cloud computing would take numerous court orders. Therefore, the data, according to Lori, was illegally obtained, she writes. And according to Riley v. California, it says hearsay anyways. Also, if the state is using geofencing from Google or location history directly from the account, the state still, and by the way, this is handwritten, so I want to emphasize that still is all caps and underlined. So I'll go back a little bit. So, location data directly from the account, the state still, underlined in caps, cannot determine who was in control of the device at all time. So any data obtained would be pure caps speculation as to an actual person's location. A phone is a small device that could be picked up by any person and transported by any person. The state has made, caps and underlined, no determination to the defense that any data turned over to the defense regarding Alex Cox is actually data from Alex Cox. And any person who knows your email address could purchase a cell phone and attach your email address to it. The defense requests this court preclude all evidence of phone data regarding Alex Cox in this trial for all of the reasons stated above, end quote. Now, first off, Lori is right that no one can prove that it was Alex Cox at the location. They can only prove that his maybe phone was at the location. But that is how they testify to it in court. I have now been to 2 of Lori's trials, about to head to her 3rd one to report every night to all of you of what's going on. And when they have testimony from expert witness about these cell phone pings, they very clearly refer to them as phone numbers in specific cell phones that are at the location. It's up to the jury to decide if that evidence means that perhaps Alex Cox was at the location. They can describe what they think maybe happens, but you're right. They cannot say that Alex Cox was there. But I also don't think that means that this should not be evidence at all. But let's see how the state responds, because that came down the docket too. And I love that. I love when the motion comes down followed by the state's reply, because we've got them both. Let's see what they say. Because the state is obviously asking the court to deny Lori's motion. They want the phone data in the trial. It's evidence. They need this evidence for the trial. And in their response, the state writes, quote, "The state of Arizona, through undersigned counsel, requests this court deny defendant's motion to preclude text messages, iCloud data, cell phone data, and Homer J. Maximus at gmail.com Google location data." And for those new to this case, that is Alex Cox's, one of his email addresses, Homer J. Maximus at gmail.com. Rumor has it he liked The Simpsons. So here we are, Homer J. Maximus. So they want to be able to use his location data. The state continues, quote, "This evidence and data were obtained pursuant to search warrants, and the text messages are admissible pursuant to Arizona Rules of Evidence, Rule 801D, 2A and E, as statements by the party opponent." On October 10th, 2019, Gilbert Police Department obtained search warrant for Verizon number 480, and I actually XXX 9120. On December 3rd, 2019, Gilbert Police Department obtained search warrant for Verizon phone numbers 480 XXX 4652, as well as 480 XXX 9120. On February 26, 2020, Gilbert Police Department obtained a search warrant for track phone number 304 XXX 5998. On December 5th, 2019, Chandler Police Department obtained search warrant for Lori for Style at iCloud.com. That would be Lori's iCloud, or one of them. And on March 30th, 2020, Chandler Police Department obtained a second search warrant for Lori for Style at iCloud.com. On January 15th, 2020, Rexburg Police Department obtained search warrant for Homer J. Maximus at gmail.com. All of the evidence the defendant seeks to preclude was lawfully obtained through multiple search warrants. Now, makes sense. Makes sense. Short, sweet, to the point was the state's reply. Moving on to Lori's third and final, for now, motion. Let's reword that. Moving on to Lori's third motion. It certainly won't be her final, I'm sure. But final for tonight, fingers crossed. And this is a motion to suppress all evidence pertaining to that Jeep Wrangler we just heard about, the Jeep Wrangler that Alex Cox was allegedly laying in wait in to then shoot and kill Brandon Boudreaux. So Lori's motion is to suppress all evidence pertaining to this Jeep Wrangler. Lori writes, quote, "Pursuant to the Fourth Amendment of the U.S. and Arizona Constitutions, the defendant, Lauren Daybell, requests this court suppress all evidence obtained as a result of illegal, unconstitutional, warrantless seizure of the Jeep Wrangler, license plate LWD0997, end quote. As for her facts related to this, well, it is all about Detective Hermosillo, stating, and I'm going to pause there, and really that's written in it. Well, this is all about Detective Hermosillo. And Detective Hermosillo, to remind everyone, is the detective who had to testify three times now, how he found the children's remains, how he unwrapped JJ's bodies in Chad Daybell's yard, how he found Tylee in a green bucket. It is one of the most heartbreaking testimonies I'll probably ever hear in my entire life. He is a Rexburg detective in law enforcement, so an Idaho detective. So as for Lori's facts related to this, it's all about Detective Hermosillo, stating, quote, on or about October 17th, 2024, approximately 7 months ago, Detective Ray Hermosillo of the Rexburg, Idaho Police Department, a state witness intended to testify in this Arizona trial, was interviewed on a podcast entitled Fax Me That Podcast. During this 2-hour, 12-minute interview featuring Detective Hermosillo, the detective informs the public how he obtained the Jeep Wrangler on November 4th, 2019. Detective Hermosillo indicates at about 5 minutes in that on Monday morning, November 4th, 2019, while driving home from the gym, he spots the Jeep in apartment complex parking lot. Number 2, Detective Hermosillo makes some phone calls and gets the Jeep impounded. Number 3, he then gets on the phone with Arizona and states, quote, I got your Jeep, end quote. Number 4, Arizona states, quote, hang tight, we have to get the warrant issued, end quote. And number 5, Detective Hermosillo then states, quote, the Jeep sat in our custody a week and a half until they showed up, end quote. Conclusion. So after seizing the Jeep Wrangler without a warrant, Detective Hermosillo then took steps to obtain a warrant. The defense, in other words, Lauren Vallow requests and Lauren Daybell requests all evidence obtained as a result of this unconstitutional warrantless seizure in violation of the Fourth Amendment be suppressed. A suppression hearing is requested, end quote. So that's Lori's third motion that came down today. Well, the state is having none of this, of course. And in the state's response, they say, quote, on November 1st, 2019, Detective Ray Hermosillo with the Rexburg Police Department spoke with Detective Nolan McDermott from the Gilbert Police Department. Detective McDermott sent a probable cause statement to Detective Hermosillo, providing probable cause to seize the 2018 Jeep Wrangler. Detective Hermosillo went to the court on November 1st, 2019, and obtained search warrant 2019-60. Detective Hermosillo documented that he obtained a search warrant for the Jeep on November 1st, 2019 in his police report. The state recently obtained a copy of search warrant 2019-60 and disclosed that the defendant on November 4, 2019, Detective Hermosillo observed the 2018 Jeep Wrangler at 565 Pioneer Road in Rexburg, Idaho. And by the way, 565 Pioneer Road is Lori Vallow Daybell's townhome, where she moved after Charles Vallow was shot and killed. So the 2018 Jeep Wrangler, before it was discovered in Arizona, was at 565 Pioneer Road in Rexburg, Idaho. Detective Hermosillo had, before and after, I should say. Detective Hermosillo had probable cause from Gilbert Police Department that the Jeep was used in the shooting in Gilbert, Arizona, and he knew that the Jeep was movable and could be driven away and had lawful authority to seize the Jeep pursuant to the search warrant that he obtained on November 1st, 2019. Detective Hermosillo documented in his police report that he seized the Jeep on November 4th, 2019, and had it towed to the Rexburg Police Department. Upon seizing the Jeep, Detective Hermosillo realized his original warrant contained the correct VIN number, the correct model for the Jeep, and the correct license plate number for the Jeep Wrangler. But there was a typographical error as to the year. Search warrant 2019-60 indicated that the Jeep was a 2008, instead of a 2018 Jeep Wrangler. Oh, here we go. Typo in a search warrant. Detective Hermosillo, though, what did he do when he discovered this typo? He immediately obtained another search warrant, SW 2019-61 for the Jeep Wrangler. Search warrant 2019-61 referenced the typo in search warrant 60. A copy of search warrant 2019-61 and Detective Hermosillo's police report that provided this information was disclosed to the defendant, Lori Vallow Daybell, on February 26, 2024. And although Detective Hermosillo could have lawfully seized the 2018 Jeep Wrangler based upon the probable cause provided by the Gilbert Police Department, he did, in fact, seize the 2018 Jeep Wrangler pursuant to a search warrant that he obtained on November 1st, 2019, 3 days before the seizure of the Jeep. End quote. I mean, it sounds like Detective Hermosillo did his due diligence once he discovered that typo. Then the state actually cites case law stating, quote, merely innocent or negligent mistakes in an affidavit will not satisfy the first prong of the Franks test. State v. Carter, end quote. In this case, Detective Hermosillo's affidavit in support of search warrant 2019-60 contains a factual basis to seize the Jeep, the Jeep's correct VIN number, the Jeep's correct license plate number, the Jeep's correct model, and the Jeep's correct color. The typographical error of indicating this was a 2008 Jeep instead of a 2018 Jeep does not invalidate the search warrant. Furthermore, upon noting this error, Detective Hermosillo obtained another search warrant to correct this mistake. The 2018 Jeep Wrangler was lawfully seized pursuant to a search warrant. The state requests this court deny defendant's motion to suppress all evidence pertaining to the Jeep Wrangler, end quote. I mean, that was pretty solid, if you ask me, according to the state's response. It's good to see so many people here. I was reading, and so I wasn't looking. I see we have nearly 4,000 people in chat. So I will answer a few questions here in a little bit. I want to first share that jury selection starts May 29th, next Thursday. And I do plan to be there in person, reporting every lunch hour and in the evenings with what is happening, breaking it down, unpacking what happened in court, and being your eyes and ears in the courtroom. For those of you that want to see these handwritten filings, you can head to patreon.com/hidden-true-crime. We're putting all of the filings we get from the docket onto patreon.com/hidden-true-crime, as well as all of our bonus episodes. It's a place we give back. And so I just want to remind everyone of those two things. You can also listen to our bonus episodes on our Apple subscription. I agree, Wendy. This month went by fast. McSpunky, thank you for your gifted membership. We want everyone to be a hidden gem. We will be also live streaming Brandon Boudreau's trial. It's Lori's trial, but for justice for Brandon Boudreau at Hidden True Crime. And we want everyone to be able to be a member. So thank you to those that gift memberships for those who might not be able to get that themselves. So recently, Megan Connor, that's Lori Vallow's cousin, Candace, did a video about Lori's father. She did some great research, and many people are asking about it. You can go find that at Third Verse or by heading to Megan Connor's YouTube channel. But I also want to state that one of Hidden True Crime's earliest episodes back in 2020, one of the first things we ever did was did a deep dive into Lori Vallow Daybell's family of origin. That includes Barry Cox. And we also dig deep into the family system of what is the Cox family. And we delve also into the divorce documents of Steve Cope and Stacy Cox. That would be Melanie Boudreau-Pulowski's parents. So I recommend that it's an audio podcast only. You can find that on Apple, Spotify. Actually, it is on audio form on YouTube as well. And then I really do recommend Megan Connor's latest episode. I listened to that, and I actually texted her and said that she did a really great job on it. So I recommend it. Krista, Lauren, what is worse, reading these motions or Chad's books? Chad's books, hands down. Chad's books are awful, but you know who does a really great job reading Chad's books is my friend Kit from Wordwise. It is so painful to read Chad Daybell's books that I'm grateful that we have another YouTube creator that does it for us. Her name is Kit, and I'm serious. You can learn so much from Chad Daybell's books. You can understand Lauren Daybell and Chad Daybell's worldview, their religious beliefs, how they believed the end of the world or doomsday beliefs, these sort of extreme prepper, ideologies, by sort of understanding Chad Daybell's books. And no one does that better than Kit from Wordwise. If somebody can put her YouTube channel in chat, it sounds like that's been done. Thank you. These motions aren't great either, but they're not as painful as some of the things I've read in Chad's books. KK, thank you for your support. You say, as a mother, she sickens me. May she rot in prison for what she did to ruin so many lives. I truly believe that she is the mastermind of it all. Difficult research. This is Crusha. Crusha is the aunt to JJ and Kay Woodcock's daughter. Hidden true crime. I believe they caught the Jeep's plate while en route to Arizona using a DEA camera set up along the interstate. Maybe the agent testifying will drop bombshell photos of Alex driving. Wow. Wouldn't that be something, Kresha? Thanks for sharing that bit of information. I think it'll also be interesting to hear, I assume, from these witnesses that saw the Jeep parked in front of Brandon Boudreaux's house. There are witnesses on the list, civilian witnesses, that I've never heard their names before. And I've been covering this case for 6 years. So my automatic assumption was that those witnesses are people that saw something that day in Gilbert, Arizona, neighbors, random witnesses that saw what happened. And I'm interested in hearing from them as well. Genevieve Carroll asked, why am I emphasizing using the Daybell name when Chad's defense includes throwing her under the bus? Lauren Vallow Daybell, and I do use both names. I know that upsets people. She has unfortunately had both names. I feel sorry for all innocent family members who are both Daybells and Vallows that she's ever had to use either of their names. I want people to know that I have empathy. At the same time, I use both names. I know this wasn't your question, Genevieve, but I'm just going to say that I have had questions about why I refer to Lauren as Lauren Vallow Daybell, and it is because she has been both. People know her as both, and I find it disheartening that she's ever been either of those names. I feel for Tammy Daybell, Heather Daybell, that she has the Daybell name. I feel for every Vallow that she's ever had the Vallow name. It is unfortunate, but people know her as both, and I, as a journalist, just try to clarify who we're talking about. Back to Genevieve's question, why is Lauren using the Daybell name when Chad's defense includes throwing her under the bus? Because Lauren doesn't think that Chad is throwing her under the bus. She thinks it's legal strategy, and Lauren is a goddess because Chad tells her so, and Chad is her best friend and someone she is married to and proud to be married to, despite him willingly throwing her under the bus. Lauren, ironically, did not throw him under the bus. She refused to let her defense team throw Chad Daybell under the bus. In fact, when they did, during closing statements in her Idaho trial back in 2023, Lauren was so angry. In closing statements, her attorney, Archibald, finally got up and said, this wasn't Lauren, this was Chad Daybell. Chad Daybell and his storm. Literally, I'm referring to what Archibald said. He referenced in his closing statements, Chad's storm. A storm was coming. It was quite the play on words by her defense team, but that it wasn't Lauren. It was Chad Daybell who was the mastermind behind it all and recommended and suggested what Lauren do. Well, that made Lauren very angry. And I have some defense sources. And what happened behind the scenes was shocking. Lauren was very upset that her defense team in those closing statements threw Chad Daybell under the bus. and said, supposedly, allegedly, behind closed doors, all of you made me look stupid. I look stupid now. Everybody thinks I'm dumb. So one thing Lori always wants to be is right and smart. And thus, she doesn't back down on her decisions and choices, even when it's, I guess, marrying Chad Daybell and believing everything he tells her. So how is Lori watching all of these interviews? I don't know. I'm going to assume that her counsel is helping her find this information while she is behind bars. When it comes to Carl's interview that she saw, where Carl, juror 15, when she was able to see Carl, juror 15 interview, because somebody sent it to the court. Someone sent it to Judge Boreski, a civilian, and thus at that moment, they had to send it to Lori. So sometimes when it refers to her case, she is able to see those things. If something is in discovery and she is representing herself, she is allowed to see those things. How long after Charles died that she moved? So fast, like that. Like she was out of there very, very soon after. I don't know the exact. I think it was the end of August. So it definitely was. Charles died, was killed, was murdered July 11th, 2019. And Tylee, the last Tylee was ever seen was September 8th, about a week after they moved to Rexburg, Idaho. And so it was at the end of August, beginning of September, when she moved to Rexburg. Why are Chad's books so bad? Is it just the content of his books, or is his writing god awful? Gringa asks. Well, both. I would say, though, that the content is really upsetting. You can see Chad's lack of empathy. I could actually see some sadism in his writing. There is one scene that is really awful. Here's an example where two missionaries go out on their mission in New Jersey, which, like, same, everything has to do with Chad's life. That's what else is eerie about Chad Daybell's books, is he gives these sort of fictional stories, but all of the characters and places are like from Chad's life. So you're like, this is Chad's life and his worldview. And these two elders, these two 19-year-old missionaries, go in to teach a family, and this little boy is being unruly. And what happens? The missionaries beat the little boy up. And then when they leave, they say, good job. He deserved it. Like, if that doesn't tell you how Chad Daybell feels about children. And I think it's also disturbing to think how many people bought these books and thought they were great. Alex Cox was absolutely cremated. Yes, his family, the Cox family, had him cremated. I was interviewing Braxton Southwick, that's Lori Vallow Daybell's cousin, and he actually explained that the way he says it is that his aunt Janice decided to cremate Alex after his autopsy. I will always wonder about further toxicology results, but alas, he was cremated. Lauren, Michelle D says, Lauren, I think I heard that Megan, that's Lori's cousin, say that the only person that had Brandon's address is Melanie. Is that true? I can't say whether or not that's true. I will say that Brandon had just barely moved, and it was a brand new address. And I don't think he had given that address out to very many people. Another great interview to watch when it comes to what happened to Brandon Boudreaux is in our Brandon Boudreaux trial playlist. We'll also link that. And in that is an interview with Brandon Boudreaux's friend, Jess. And she sort of talks a little bit more and gets a little bit more information. But I cannot say whether or not that is true. Martina asks, are Chad Daybell and Lori Daybell still communicating? I'm going to speculate, because I have a little bit of evidence, behind the scenes evidence from some sources, that yes, I do believe they are still communicating. It's complicated, though, because Chad Daybell is on death row and Lori Vallow Daybell is serving 3 consecutive life sentences and is going to now have another one from Arizona. So I believe that somebody is helping them to communicate. And I'll let all of you speculate who that might be. Thank you, Sunny, for the gifted membership. And thank you, ShareBear88, for the gifted membership. Was the house not mostly empty when Charles was killed? It was absolutely empty, minus clothing and some stuff in one of the bedrooms. Melanie Gibb had actually been staying at the house. They had just moved in. But I think one thing that the state of Arizona was really trying to drive home in front of the jurors without saying it is that this was planned, that Charles Vallow's murder was planned, and it was planned by not even having any furniture in the house. He walked into an empty house, and it made him an easier target. They had just moved into the house. They had not furnished it, but they did have beds and other items in the bedrooms. It was just not the living room. B. Haskin asked, do you think Lori needs validation from men or just someone to share crazy ideas with her? I think she expects validation from men, and I think she's often shocked when she doesn't get that. And I'm thinking of Judge Bresky at this time. The video of Lori and Chad dropping off the tires at a storage better come into trial. I hope it does. I was sort of surprised at the evidence that was not in Charles Vallow's trial that we had all seen, like body cam footage, but I do believe that it will likely come into evidence at this trial, and I would assume that might even be why Ray Hermosillo is testifying. Ray Hermosillo is a Rexburg, Idaho detective who will be testifying in Arizona. He's the only Idaho law enforcement that's listed to testify. So I think we just learned why he will be. We learned that he is the one who obtained the search warrant for the Jeep in Idaho, and that they seized the Jeep in Idaho. So Idaho is going to be coming into play into this trial. So this video of Chad dropping off the Jeep tire at the storage unit, I do believe, if I'm going to speculate, will come into evidence at this trial for Brandon Boudreaux. For those that are new to this storage unit video, it is so compelling what we see. It's also funny. It says a lot about Alex and Chad. What we see is we see Lori walking in to drop the Jeep tire off. Lori with a man dropping the Jeep tire off. And we then see someone putting the tire, and then it's a couple of days. That would be when they're in Arizona, or Alex Cox is in Arizona, takes the Jeep without the tire. So they put the Jeep tire in storage in Idaho before the shooting in Arizona, meaning they drive. I think what it's inferring that they drive, implying the evidence implies that then they drive the Jeep to Arizona without the tire, so that a barrel of a gun can stick out of the back of the Jeep. He also, as we've just learned from the state's motion, got the windows tinted. Alex Cox did. And then once the Jeep comes back from Arizona, the tire goes back, the Jeep tire comes out of storage and is placed back onto the Jeep Wrangler. The two videos are so funny because one of them is with Alex Cox and one of them is with Chad. And when it's Alex Cox with Lori, he's carrying the tire. He lifts the tire up to move it from in and out of storage. When it's Chad Daybell, the poor guy is rolling the tire because he can't pick it up, and then grabbing Lori from her behind on her jeans, while of course Chad Daybell is still married. So this whole idea of Lori saying we were just best friends. Okay, well, everybody check out that storage unit video and decide if they were simply just best friends. Thank you, Aaron, and thank you for being a member for 17 months. Thank you for your deep dives and continuing coverage. Lynn asks something that everybody's been wondering. Is Melanie Pawlowski going to testify in this upcoming trial in Arizona next month? No. She is not on the state's witness list nor Lori's witness list. Wild, right? So It's interesting, right? I don't know if she's unreliable or if I don't know. We certainly learned during Chad's trial that Melanie Pulaski knew some things because we heard the Ian Pulowski tapes that were recorded for the FBI where they talk about Alex Cox and how and the shooting. Difficult research. I'm so glad to see that you've become a member. Mindy, Hidden Gem for 27 months. Thank you, Lauren. I love all the tea. I am here for the tea. Can the prosecution call Chad as a witness regarding the storage video? It's a great question. Whether or not they can, because he's on death row in Idaho, I don't know, but they have not. He is not on the witness list. No Chad Daybell. You guys, thank you everyone for being here tonight. This was it's always good to go live. I know that I do my produced videos and I put them up, and that response from Lori came down really, really late last night. So I was up till 2 a.m. Getting that together, producing that, and then we threw it up early this morning. So I can't always go live. And then when I can go live, like tonight, I love that. And again, I will be going live every night of trial next month, as well as doing my lunch lives and doing episodes with Dr. John Matthias, my co-host, who's a clinical and forensic psychologist. I also want all of you to know that we are doing many things behind the scenes as well here at Hidden True Crime. We are doing some deep dives into some investigative journalism. We'll be bringing you many more cases. And another case that I want you guys to notice, we dropped it a couple of, or last week. The days are a blur as I prepare to head back to Arizona. But Marsha Norman is a victim. It's a horrendous case out of Washington State. And Jeffrey Ziz is been charged with murdering 82-year-old Marsha. And I shared this story. It is an upsetting story. It's my trigger warning. And then Dr. John Matthias, my co-host, who is also my husband, assessed what in the world was happening in this case. It's upsetting because Jeffrey Ziz was on probation, and he had been a pastor in the military and was Marsha's handyman. And we'll put those links in the chat right here if anybody has them, because it is it's hard to listen to. Again, trigger warning, but it is something where we want to see Marsha get justice and bear witness to what happened to her. All right. Thank you, everybody. So again, I will have the link to the earlier video I did today in pinned in comments, as well as in the description, as well as our Patreon, patreon.com/hidden2crime, as well as the Brandon Boudreaux playlist. So it'll be Lori Vallow's trial, #justice for Brandon Boudreaux. I think that's what it's called, something like that. And we are putting together all of the important shows and episodes here that pertain to Brandon's case, so all of you can get caught up. May justice be served. We'll see y'all.